G'day, Nina. Welcome back.
Thanks, Andrew. It's nice to be back.
It's lovely to have you back, I've got to tell you.
Yeah,
I've had
it's
some
been
very
nice
scared
eating
people sitting in your chair. Poor Chewy, I dropped him into the last minute
back.
last week.
Yeah, you weren't very nice.
Kim's a reluctant participant at the best of times.
Yes. But, I think they both did an amazing job.
I think they did, considering they're working with me. Yeah, I think they do very well.
I think they should regularly sub in for me.
No, you're here. Interesting, we've got some interesting things this week. We'll talk a little bit about the development that's been happening in Queensland shortly, but I think Nina and I have been saying for some time that regulators are dipping their toe in the water at pursuing workers for their primary duty breach of exercising reasonable care to prevent them injury to self or others.
Yeah.
Section 25 here, 28 in WHS states. So we've got a number of cases on that, and you can really see the escalating tension that exists there, and also the willingness to really go hard and give it a bit of a shot.
Yeah, I think it's really interesting because previously it's always been, if it was an employee, it was like a supervisor or someone who's directly managing, but now it's like all gloves off.
Yeah, which brings us back to unions, really, doesn't it? I think just out of interest, what we're seeing throughout the world is quite a bit of change going. We're seeing reunionising of many places, particularly in the States, because post-COVID there was no support for employers or employees. The wages are incredibly low, there's no holidays, and as the American economy recovers to the extent that it is recovering, workers are being treated worse than ever. And as a result of that, you're seeing reunionisation. Now, in Australia, we haven't seen that happen. There's such a talent shortage here that people are mostly being paid well just to get them through the door. But the other problem for the Australian union movement is it delivered its platform by 2010. So all the things you see in enterprise agreement, we're now starting to see a greater focus on women, which is good. But in Queensland recently, we've seen this look at long-term health concerns like IVF to try and get leave for people.
Well, they've actually implemented it for the public sector, that they get 10 days of non-cumulative leave for any reproductive medical conditions like endometriosis.
That's right.
IVF and things like screening for breast cancer, things like that.
And what we'll see again within 5 years' time, there won't be many days that people actually have to come to work, because as they gradually increase the various leave entitlements that exist there to deal with what are genuine problems, we're finding the union becoming incredibly stuck and wedged in these new ideas to try and create new change. So good argument, nothing wrong with the argument, nothing wrong with why people are seeking it. But I guess as employers, and I'm an employer, I need productivity and I need output, and there has to be a balance we strike between what are the choices people make and what are their health issues versus what's the obligation of an employer to support an employee.
Yeah, but I think this is going to be just like family and domestic violence leave. Like when the unions first pushed it, everyone said, oh, this is going to be halt productivity, but there's specific guidelines to meet it. It's not just like everyone can do it. And I suspect if it's anything like that, they'll have to go through all of their sick leave and things first. So I think it's not worth fighting over and agitating the union if it's only going to help them push their platform. Like that's not actually what it's about.
Look, interesting. I think the reason I wanted to raise it is we have seen an exhausted union in Australia failing at every level, completely failed over closing loopholes.
And right to disconnect.
Yeah, right to disconnect. What an utter and abject failure they've made, because Australians just went, it's just horse shit.
And it's the law is already like that.
Yeah, so in a way we've got a voice that's fairly flattened by their incredible success during the 90s and early 2000s. But for employers, the lesson for all this is stay close to your people and actually look after them. And if you have got an employee who's going through awful IVF, why wouldn't you support them?
Yeah.
Why would you wait for some rule change to actually create that opportunity when you should be embracing that person and looking after them? Anyway, look, that's probably enough on that subject, but it's just a change. I tell you what, the next case, which is Little and the Commissioner of Police, I reckon is a real game changer. So out of the cases we're going to talk about today, none of it's particularly new law. This is not new law, but it's new application of law.
Yeah.
So now you talk a bit about the facts.
So it's an appeal case involving the WA State state, obviously, WA Police. So this police officer started, I think, in 2014, and it was in 2018 that they found out he had quite a serious shoulder injury and was taking quite significant medication and was suing the UK NHS because they'd caused it. He had failed to disclose any of that during his pre-employment checklist, and his condition meant he couldn't perform the role. Like basically,
couldn't fire.
Yeah.
Couldn't apprehend a villain.
Yeah, and he couldn't
Drive a car.
So like all things that a police officer needs to do, and so he was placing himself and other people at risk. But not only did he not disclose it, he actually went out of his way to conceal it and was dishonest about it as well. And so they terminated him. And I want to say they did quite a long process. Like most people would have, I think it took them a couple of years to do it because they were very, very thorough. But he appealed it and said it was unfair. And the appeal court found that no, there is a positive obligation under, it was the repealed WA, and basically under Section 28 of all the WHS legislation, that if there is a hazard, you have to disclose it because it can impact the health and safety.
Can I just say that is, if anything, that Section 25 of Victoria, which is to exercise reasonable care, a competent person doing their job would know that the job they're doing based on their physical status, or the job they're about to do based on their physical status, would not be safe for them or others. And what's interesting about the appeal court is it actually adopts the phrase a positive obligation. So,
well, I don't think they went so far to say that specifically, but they implied.
But the importance of that, Nina, is you've got the sort of Section 22 obligations on an organisation to monitor health, so to actually determine whether somebody is fit for work. But I think the courts have been most reluctant in the past to say, well, wait a second, there's this other worker obligation, which is if you know you're not fit for work, then you really got to do something about it. You've got to put your hand up. So it's not just in the termination of employees. This is about a putting your hand up obligation that we can start to use more effectively. In Victoria and Queensland, they've got the Section 41 under the WRC legislation.
Which is what we've always relied on, and you definitely still should.
Which is the disclosure of pre-existing injuries or illnesses that prevent you from undertaking the work that you've been engaged to do. But I just want to put this out there. This is more than a termination argument. It's a complex termination argument. And the reason they took 2 years is there's a whole lot of discrimination risk that sits along the pathway of not getting it right. But this is a discussion we have with our employees every day when they come to work and they're not fit, to say, look, you just can't turn up. You're obliged to tell us. So that's why I say, although this has been the law, it has never been utilised in the manner in which it's been done before. And it is a real game changer for how we manage people, particularly post-COVID, where we find that illness and injury is a much harder discussion.
But I also think caution needs to be applied when using this. It's not a free-for-all that if someone has
Nina's only just back. She's being much more cautious than before. Wait till I get to my favourite subject, she'll blow it shortly.
We also don't want people to think that this is like if someone hasn't disclosed it, then you've got a guaranteed termination. It's in this case, it was very clear that the condition was directly relevant to the role. Like if I had a shoulder injury, that's not grounds for you to say that, look,
no, it is because you carry me.
I feel like I'm carrying this right now. It's the briefing right now. Gosh. But you understand my point.
You tell the truth. When you went away on your wedding, you felt 110 kilos lighter because you weren't carrying me.
I won't make no comment. But yeah, so I think it's great that we now have this tool and the courts support it, but use it carefully.
Yeah, and use it where it's best used, which is you're having a conversation with someone, they're showing signs of mental distress or physical injury, and you want to have a conversation about their responsibility of disclosure and engagement and say, look, actually, when you're not fit for work, you've got to tell us. We can't help you if you don't. Do you see what I mean?
Yeah.
What a game changer it is, because people worry about having a conversation. Here, we've got the conversation.
Yeah.
It's just lovely. All right, look, let's go on to Lockdale and Lynn, which is a restraint case. I just want to deal with this very quickly because it's a brief and beautiful case.
But you've skipped a case.
Have I skipped a case?
Is that on purpose?
No, it's straight to casual hairdresser. I'm sure I'm right.
No, the next one is the double charges in New South Wales.
Are they?
But we can talk about that one if you want.
Double charges. Let's say double charges in New South Wales, because I got a bit excited about the restraint case. But the double charges in New South Wales are directly the worker liability issue that we're talking about. And funnily enough, it mirrors an issue that happened to Nina and I only a few weeks ago with a client about a vehicle that was where no brake is applied and it was left.
Yes,
yeah,
that's right.
And I was reading and I was going, oh my God, this is very familiar territory. But the worker who was in charge of this forklift, which was not secured, was turned on, but no brake on it.
And it was on a slope.
And then it's on a slope, yes. And it rolled back.
And crushed another truck driver between the forklift and his
yeah,
truck.
he was charged with Crimes Act manslaughter because New South Wales doesn't have a workplace manslaughter, for which he got 2 years plus 6 months home detention.
Oh, he
2 months
pled
wholly
to
suspended, wasn't it?
Yeah, he pled to a lesser charge of dangerous driving because
Okay.
they made a deal, so it wasn't manslaughter.
Yeah, so he ended up, but with 6 months home detention.
Yes, that's right.
But he was also charged under the worker breach of Section 28, Victorian Section 25, for which he ended up with a $7,500 fine.
Yeah, because of the principle of double
jeopardy.
That's it.
Yeah.
And he couldn't pay it. But I think it's not so much how much he had to pay; it's the fact that
they did it.
They did it, yeah, under both. Like Safe Work was not going to let him go.
So just be clear about this. They went for the industrial manslaughter, but they also went because they're allowed to. It's not the word's called duplicity. There are different elements that make up the breach under 25, 28 and manslaughter. So there are different parts that apply to it. So you can be charged with both.
Yep.
But I just want to put this out there one more time. This is another motorised plant issue. It's not the only one we're dealing with today, I don't think. So motorised plants are the most frequently charged issues. This is something which is an inherently dangerous vehicle dealt with negligently. When you say negligently, you're already into the industrial manslaughter part of it. As a worker, he could not be charged with industrial manslaughter because he's not an officer.
No.
For the purpose of this. But can you see where this is going? I guess that's the part that I'm saying. We're seeing workers charged using multiple pieces of legislation to try and get personal deterrence.
Yeah, and I think it's a good thing because how many times do we read cases where the worker's done something clearly wrong and it's the employer who gets charged? Because yes, they've got obligations to make sure they're complying.
You're getting onto your
well.
theme. You're starting to build up to it, aren't you? She's building up this theme. You wait. She's going to come out of the blocks very shortly.
But also the fact that if they've done the wrong thing, they should be punished.
Good. Yeah. That's what you're saying. Okay, can we have the hairdresser now?
Yes, you can have the restraint case now.
Okay. Look, the hairdresser case, this is not the first hairdresser restraint case. In fact, one of the early restraint cases. This is a family business that was sold. One of the members of the family stayed on as an employee, signed a new contract. They had a 2-year non-compete clause plus some generalised terms. They sought $85,000 from a hairdresser.
Because they started their own company 6 months after or something.
Yeah. But, well, actually, it was almost the same day. So they went out, they finished their work and then opened up their own business and advertised on Facebook after they did it. But my point about all this is the court gave us some beautiful clarity around how you actually determine what is a reasonable restraint. They said, how often do people come and see hairdressers? So if it's every 6 weeks, then maybe a 10-week restraint's fine, but a 2-year restraint could never be fine. And I want you to think about that in your own business. What is the transactional nature of your business that you're actually seeking to protect? I thought that was great. The second thing is they reasserted the nature of the test, which is a restraint will not survive if it is not reasonable. And that means you go to precision about exactly what it is you're restraining, which failed here as well. But they kept coming back and going, but this is a young woman. This is a young woman who's a hairdresser who really doesn't own a lot of goodwill. Why would you think it's worthwhile or proper to restrain this person?
And because people change their hairdressers quite often, so there is no real goodwill.
Yeah, well, that's something I probably don't know about because, as you know, Toy cuts my hair with a dog shears. But other than that, my point about this case is don't use restraints for junior people. Look at the transactional nature of your business to actually build the evidence upon what the nature of the restraint is. When it comes to defining what is a business, spend real care to define what that is. Okay, that's all I wanted to say because I just think it's a lovely case that talks to the heart of what is a restraint in a very simple way. Are we off to my next case now?
Yeah, now we're about the heat in the moment resignation.
Heat of the moment resignation. This is a case, can I just say, where the judge opted for a Scottish accent to get out of jail and make an easy comment. Okay, so this is an argument that existed between an employee and their boss.
Yeah, the same kind of thing where they had an argument, the employee left in
They
tears.
said they came out. This is the limbic. I call this the limbic lie. Two people sit in a room. They say something, and both of them hear completely different things.
Yeah.
I think it's probably right that she did say she was resigning, to be honest. But the judge thought the easiest way to say this is she's got a Scottish accent. I can't understand what she said. I'll just say that's the case. This is a heat of the moment resignation case. That's what this really is, with a nice Scottish flair at the end of it. And the bottom line is whether she did resign or didn't resign, what the judge ultimately said is, or the commissioner ultimately said is, look, she showed all the indications that she was continuing in her employment and she was very distressed at the time. You can't just grab what she said, misunderstood or not, and pretend it's a resignation.
Because she sought to correct that misunderstanding too, and they were like, nope, you've resigned.
Yeah. All right, I think we're on to our next case.
Which is another excavator one.
Another excavator case? This is Shivani's case, is it? No, this is Grimo. We seem to miss Shivani and WSP in that process.
No, that's the next
It's
one.
the next one. I've got way ahead of myself.
Yeah, he's just jumping everywhere.
I know, I'm ahead of myself today. That doesn't often happen. Okay, this is another individual liability case. Launceston Magistrates Court. Low fine for a person who failed to provide appropriate system around.
It was 55,000.
Motorised plant.
Yeah, but for the individual, I think that's quite high.
Was it 55?
Yeah.
Oh, I didn't realise it was that high.
No, it was, and he wasn't like a supervisor or anything. This is just an ordinary employee, and I think is the best example of WorkSafe saying, it doesn't matter who you are. If you're doing the wrong thing, we're going to prosecute you.
Wow.
Yeah.
I think
it was breach of section 28.
Did you do this case?
No.
No, I don't think that's right. I think it's I think he got fined $7,000. I think that's what the company got fined.
Oh, okay.
So it's a great case, but I don't think what we told you is the truth. But again, it's an excavator. It's failing to ensure there's safety around it and an individual being prosecuted. And what we're seeing across Australia now is all regulators being really focused on motorised plant.
Yeah.
Okay, and now they're starting to go after individuals. So we've got something to say to our workers. We can just say, look, it's not just me anymore, it's you.
Yep.
Next case is a brief one. I don't want to spend.
Shivani.
Yeah, Shivani's case. This is a case where there were 10 people in a room. 9 were men, 1 was a woman. She was an observer. There was meant to be another observer, and the observers were meant to get coffees for the group. That's the background of it. But
for the training session.
For the training session, it turned out that on any form of the evidence, it is accepted. She was the only observer attendant, so she was to get the coffee. But in the
they asked also, they didn't direct her. They just said, "Can you get the coffee?"
And she took that as being sexual harassment. And the judge said, "Well, that's your subjective interpretation of it, but the test around sexual harassment is objective, not subjective. In other words, would a reasonable person observing what occurred feel they are being sexually harassed? In this case, it's not. It's an unfortunate. Somebody with a bit more wit might have thought more carefully about what they did, and it is the type of thing, if it happened more than once or twice, could create a hostile workplace now with the positive duties that exist there. But it's just an example of how easily people perceive risk and hurt in circumstance, and you need to reflect a little bit when you're handing out jobs.
But her answer when the court asked her, why did she think it was? She said, oh, because there was an example in the training. So
Unless you read it.
Yeah, but I think, yes, potentially definitely could be sex-based harassment, asking the only female to do it. But I think if they didn't have all that other evidence, she might have had more of a case.
Yeah. I guess why I put the case in, it's me who did it, is I don't blame her for feeling like that. If I was a woman, and I'm clearly not, just because look at me, and I walked in a room full of 9 men and someone said, could you go and get the coffee? I couldn't help but feel that there's something about the gender politics of the room that led me to that, even if it was innocuous and not meant that way. And I guess what I'm saying to people is, look, can you just reflect a little bit?
Yeah, like be careful.
Just be careful, not because of litigation, but be careful of people.
Just be nice.
Yeah, there's no need to do it. Now, here's the case that sets Nina off. We're going to unconscionability, and this is our major topic. So before Nina goes absolutely crackers, I just want a couple of minutes of safe time for me. What we've seen since the Qantas decision, where the judges dug deep into not only Qantas's behaviour, but the intentions that sat behind that behaviour, is a willingness of courts and tribunals to try and understand what was driving the behaviour of the employer. And the case that we're talking about today is a woman who'd been on a permanent contract for 10 years. She was picked up a second job, and then they said to her, and this is the best version of it, look, you've complained about so much work. Do you want to just do the company secretary, but that'd be a fixed term one? Or do you want to do the other one and we'll get someone else to do it? That's effectively what they said. But they never said to her, if you take the fixed term one, you cease being a permanent employee and you lose all your rights under unfair dismissal. Look at Nate, she's doing it already. I think when you come to us, we spend a lot of time engaging on strategies, sometimes to get an outcome which is counterintuitive to the facts we're presented with. And we build evidence around things to establish a pathway of legitimacy of decisions you have to make because of the complex people you've got involved with. I think this is a case about an organisation that was trying to rid themselves of somebody and found a useful method of doing it. But what the courts have done here, and they talked about it in Qantas as well, is they've started to look at more commercial terms of fairness around power and knowledge. And when you represent something, if you fail to tell someone, that it's a misrepresentation. So they've grabbed hold of this. It is unconscionable when you're a person in power to represent to someone, well, you can have this and that solves your problem, without telling them they lose all their entitlements. Nina.
I just think it's ridiculous because, right, in this discussion, I'm not condoning what they did, but in this discussion, she was presented with the two options. She's also not a junior employee. She's quite a senior role. She was company secretary, right? Yeah. So she could have gone and sought her own legal advice. The idea that an employer, when they're doing any kind of negotiation, say like reasonable business hours or a request for flexible working request, having to step out to an employee, here's the benefits and disadvantages of each option, is just bizarre.
But can I just say, dirty cases produce not good law sometimes. You know, from the Qantas decision, this digging deep into Qantas decision making. This case, clearly the judge or commissioner, whoever was involved, really took a very nasty view of the behaviour of the organisation. Yeah. And they've tried to find some tools to actually determine why this person could get a jurisdiction to bring an unfair dismissal claim. And I guess my answer about this is it's here to stay. So you can wrestle with me as much as you like, but courts are going to start digging deeper into employer behaviour, partly because these are beneficial legislation to protect workers.
But it's already so beneficial.
But we're starting to get, well, it's probably not our experience generally, but 2 or 3 plaintiff-based firms who are really quite clever, who are now starting to know where to go to light the fire. And we're going to see much more of this argument. So I'm just raising unconscionability, talking about what does it mean when you have a difference in power? What's the level of disclosure? For the stuff you come to us and we say, I know you need to get rid of this person, but the method you want to do is not going to work. You need to do something like this. You've got to listen more carefully to the evidence development, and you've got to make sure you're not sending texts and messages which are contrary to it. So you can still structure the process, but that nasty vituperative stuff of gossiping behind the scenes and stabbing someone in the back, they're the things that come home to haunt you. And this is a case where whatever the tribunal was, didn't like the employer at all.
Yeah, I want to make clear, I'm not condoning unconscionable behaviour, but I guess what I'm saying is it just seems like it's skewed once more to the employees. But like Andrew said, there are still ways to do things and make sure you have the right evidence to support it, and then you'll be okay.
And remember, it is a beneficial jurisdiction. It's there to protect employees, Nina.
You're just trying to set me up.
It was fun, wasn't it? Okay, so let's get on now to our case study.
Which I haven't had a chance to read yet. Ambrose had played AFL. Like most players, he had numerous surgeries, but retired because of non-surgical problem in his left knee. He was a diabetic, and even by the age of 34, had some peripheral neuritis, leading to the rare disease of neuropathic arthropathy.
When you come back, I always put in a few words.
What is a Charcot knee?
That's what it's called. It's Charcot knee.
The repeated microdamage to the knee, playing football, and systemic peripheral nerve damage from diabetes, although in its infancy, made his left knee weak and prone to giving way. He applied for work with Skinny Scaffold upon his retirement from football as a labourer. He was asked to sign a Section 41 WIRC disclosure requiring him to disclose any pre-existing injury or disease. His offer of employment required him to warrant, based on his state of knowledge at the time, there was no injury or disease that would prevent him from safely undertaking the inherent requirements of the job set out in the schedule. The schedule set out the role and tasks required of him, including carrying scaffold material up to 25 kilos. Although to look at him, he was built like a tank, he disclosed he had played football and had multiple surgeries. 3 weeks after starting work, he was climbing a ladder between the 3rd and 4th floors, carrying a small bucket of couplers. As he reached the top rung, his knee gave way and he slipped and fell to the platform below. The bucket of couplers fell through the protective netting onto the ground below, narrowly missing a team of workers. The fall of 2 meters left him unconscious. As he woke up, he said to the foreman, "My effing left knee is rooted." Subsequent discussions revealed he knew of the pre-existing injury and disease process known as whatever it is.
You're about to get dropped.
SS summarily.
So you do understand that I do this to Nina every week, don't I?
Well, we've got record of you bullying me now every week. SS summarily terminated his employment for failure to disclose under his contract of employment and sought to reject his workers' compensation claim. Then I'd support it. Boris Blackburn, oh my God, well-known plaintiff lawyers commenced a general protections claim. Wow, so original.
Okay, would Ambrose have any chance of his workers' compensation claim being accepted, and what would be the impact of the termination of his employment? So he did disclose that he had multiple surgeries. He didn't disclose that this was non-surgical in nature.
Yeah.
And he knew at the time of doing that. So the answer is, would his claim be accepted because it arose at a pre-existing time? And he
didn't disclose it, right?
Yeah, the difficulty with this is it's not an injury that arose at another workplace. It is a disease process that existed in his
neck. Like a non-work injury.
So I think that his workers' comp would probably be accepted, and the termination of his employment means that it'd cap out the workers' comp insurance.
Really? Just because it's non-work related?
Yeah, look, at the idea of Section 41 is to capture, just say you injured yourself at last place of work. So it's really an indemnity clause.
Oh.
And then you come and work for me and you don't disclose it, then the liability falls on the past employer, not on this employer. So therefore you can say no to it.
Yeah.
And Section 41 can be used, but not properly used for the termination of employment, because you're not allowed to use Section 41 under the Act to terminate someone.
Yeah.
I hope everyone understands you can't use the benefits of workers' compensation legislation for non-workers' compensation.
Yes, that's right. Yeah.
So I just thought I'd explain the technicality in the middle of it. You'd have an argument of rejecting the workers' comp. It'd be worth a shot. But I think at the end of the day, it would be accepted. But the termination of employment that comes afterwards with a person with that nature of the knee injury, if it is accepted, is a premium killer. So what other work you could do, different question about a return to work and safe return to work. But if you're a large scaffolder, say you had $5 million worth of REM, you probably just added $1 million over 3 years onto your premium. So not a great thing to do. 2, was Skinny Scaffold safe to terminate Ambrose given his failure to disclose, and are there risks for general protections claim or any discrimination argument? Now, this is the different argument, and this is the little and police argument of saying he had a duty to disclose to them once he knew what the nature of the job, and the schedule was very accurate about the nature of the work that was going to be undertaken. Had he applied his mind that, he would have said, no, I can't do it. Particularly climbing as well, the types of things would aggravate it.
And because he was carrying stuff that could be dropped onto other people, like it's a very high risk.
Yeah, you can see at the moment why the failure to do a pre-medical in heavy lifting, bending, climbing professions is a huge mistake.
Yeah.
Because none of these problems would have existed at all if proper pre-medical had been done. Yep. But I understand the shortage of supply of talent at the moment means you're grabbing whoever you can. He looks a big, strong guy, so why wouldn't you go with him? But the short answer is, I think the general protections claim would have no chance of success using little as an argument here because of the dishonesty and the knowledge at the time at which he did this. I think you're pretty safe with it.
Yeah, because general protections, it's not just that they have a condition, it's that you had to terminate them because you were discriminated on the basis of that. And that wouldn't be discrimination in this case because they can't meet the inherent requirements.
So there was a clear swimmings that said all scaffold equipment over 5 kilograms was not to be carried by hand, given the use of ladders, and a requirement for 3 points of connection. In other words, when you're going up a ladder, you must have 3 points of connection as you're going, so you can't do it. Ambrose and other workers were not inducted into the rule. Are the safety risks for SS?
Yes.
They're a huge safety risk for SS.
Because they could say they weren't aware of that.
Yeah, and he suffered, he collapsed, but they could have killed someone with the couplers that went over the edge.
Yeah.
I think they're in a bit of trouble, and it's not just a primary duty breach at that
Right.
stage. I think it's something much more serious. Once Ambrose disclosed the physical issues in general terms, what should have SS done? Given their failure to do anything like that, what was their risk?
Do a fitness assessment.
Yeah, and their failure to do that is a complete breach of their own obligations under the Act of monitoring and managing health and providing a safe place of work. So I think once somebody says to you, I've had a number of bits of surgery and I've played AFL footy, you'd really want to test the person to know what they can and can't do, no matter how big their biceps were, really. So I think you're in real safety target territory doing that, because you put on knowledge of a risk, but you don't know what the risk is. Would Ambrose's chance of succeeding in workplace claims be improved if he had complained of carrying and climbing, citing safety concerns? And at his termination meeting, they described him as a troublemaker, complaining all the time about safety. So, in other words, if he raised the concerns about the climbing and carrying,
about the mean,
and when they terminate him, they said specifically, "You're a real troublemaker around safety." He has all entitlements come.
Yeah, because then there's evidence of them taking adverse action on basis of workplace
and there's discrimination under safety law as well.
Yeah.
So I just thought I'd add all those things together. We're running a little bit late today because Nene got a bit fixated on that issue.
I think you purposely worked me up. I think we're over time because you made all these random comments.
And I chucked in words you couldn't say, as always. But look, lovely to have Nina back, and really lovely to see all of you. Thumbs up,
give
please.
Give us a thumbs up.
See you later. Cheers.
Bye.